We are recording this. I hope no one objects. If so, speak now.
All right, I think we can get started. And if anyone else is able to join a few minutes late, that's totally fine. We'll make sure that we let them in. And as you all just saw, this meeting is being recorded. And so there'll be an opportunity to view this later on. And if you didn't already, you should be getting a copy of the slides as well, so you can go back to them at a later date. So yeah, we can get started. I think Hirsch has some opening words for everyone.
Great. Thanks, Lauren. And hey, everyone, it's great to be with you today. We're really excited for this conversation that we're going to have today on leading issues in California cannabis law and policy. And, before we jump into the discussion, we'll just have a quick introduction. I think we'll start by talking through why we're here today, why we're talking about California, and the fact that it's a unique market. After that, I'm going to pass it back over to Lauren, who's going to read a quick legal disclaimer. And then she and I will both introduce ourselves, tell you a little bit about us, and then we'll highlight the key topics that we want to cover today. And then we'll jump into those topics and the discussion. So, just to start, big picture before jumping into things, we thought it would be helpful to consider why we're talking about the California market. And the reason that we're talking about the California market is first, because it's the biggest market in the country, and it is going to be one of the biggest cannabis markets in the world, as many of us know. And also, it just has a source of immense cultural capital when it comes to cannabis. The modern cannabis reform movement started in California with Prop 215 in 1996. And many folks in the legal cannabis industry often talk about how the best brands are going to come from California. So California, represents a unique place in the imagination when it comes to cannabis. But at the same time, California is one of the most challenged markets out there. Despite its immense potential and promise and the amount of excitement around it, it has one of the most difficult regulatory environments that exist. And so I think that's why we're here having this webinar today, that the state has immense promise and cultural history, and yet is one of the most challenged legal markets in the country. And, it's worth noting that we're kind of at an inflection point in California cannabis. We've had a legal market for 4.5 years. We've recently seen reforms. And I think the purpose of the presentation today and our conversation is to touch on those themes, the immense promise and potential that the California market has, but also the challenges that continue to restrict its ability to thrive. And Lauren and I are going to be talking through where we've seen progress and how much further we have to go. So that's the context for this conversation. I think I will pass it to Lauren to give a quick legal disclaimer.
Yes, so hi everyone, and I also just wanted to give a quick thank you and shout out to California NORML for hosting this webinar. Hirsch and I are both on the board of directors of California NORML, honored to be on that board. We're both lawyers, but some disclaimers: even though we're both lawyers, the information in this presentation is not intended, nor should it be construed as legal advice. You should consult with an attorney with any specific legal questions. Simply transmitting or watching this presentation does not create an attorney-client relationship between you and the presenters. And furthermore, the laws and regulations in the cannabis industry are rapidly changing, and it's possible that by the time you read or watch this, it could be outdated. Neither the presenters nor California NORML make any warranty, express or implied, for the accuracy or reliability of anything herein, and disclaim all liability related to any actions taken or not taken by recipients based on the contents of this presentation. Some legalese for you. This is not legal advice, essentially. And then some introductions. Hirsch, Hirsch, tell us about yourself.
Yeah, thanks, Lauren. Like you, I'm a member of the CalNormal board. I also founded a cannabis consulting firm called Ananda Strategy, which works with many of the leading cannabis brands and retailers in California. And I'm also the vice chair of the California Cannabis Chamber of Commerce. Lauren?
Yes, I am Lauren Mendelson. I'm the Senior Associate Attorney at the law offices of Omar Figueroa, based in Sonoma County, and we work with cannabis, hemp, and psychedelic clients throughout California, as well as in New York, where we recently opened an office. I have been, doing a lot of activism work for many years. That's kind of how I came to being a lawyer. I work with groups like Students for Sensible Drug Policy in college and law school. I mentioned that I'm on the board of California NORML. I was involved with the International Cannabis Bar Association, a Sonoma County Growers Alliance, Sonoma County chapter of the ACLU of Northern California. I really enjoy working with clients as they transition from, kind of how things were in the past through this complicated quagmire of all these regulations. It's difficult, but, folks like Hirsch and I are there to help folks through it and to keep advocating for the situation to get better. And before we move on, I just wanted to address something that someone mentioned. It looks like Ellen has addressed that, but yes, I don't, in terms of just, this is being recorded. So yes, if you don't want to be recorded, then please turn off your camera and your microphone, but it's being recorded so that other folks can watch this presentation. All right, let's move on. And here's an outline.
Yeah, thanks, Lauren. We thought before jumping into the discussion, we just go over at a high level the topics that we were going to cover today. And, there's really 5 key topics that we're going to be discussing. The first 2 topics really hit on the challenges with California's market. So the first topic we're going to talk through is taxation, and we're going to talk through the immense burden that cannabis businesses in California face. We'll walk through all the taxes that they're subject to, also highlight recent efforts to reform the tax system, and then talk through what we can expect going forward to reduce the tax burden. So that's the first thing, which is one of California's big challenges, which is taxes. The second thing that we're going to talk through is retail licensing. And again, we're going to discuss how this is one of the big challenges for the state, the lack of access points for legal cannabis. And just like taxes, we'll trace the history of retail expansion across the state, recent progress we've made to address this issue, and what we can expect going forward. So that's the second topic. Third, we're going to talk through provisional and annual licenses. And here, Lauren's really going to do a deep dive in explaining the difference between a provisional and annual license, which is something that may be unfamiliar to most folks. And she's going to explain how consequential this will be for the future growth of California's industry. And then the 2 other topics we'll cover. The fourth one is the illicit market. And here we'll tie this back to the first 2 topics we covered, taxation and retail access, and how this contributes to the illicit market in California. And then finally, we'll talk through new regulations that the DCC, the state agency, has issued. So that'll be the 5 main topics. And then there's additional topics that we may cover as well.
And yes, there will be time for a Q&A at the end. All right, so first, there's a few key terms here that I just want to go over. You're likely familiar with all or most of these, but just so we can get on the same page. If we're talking about commercial cannabis, we're talking about activities relating to cannabis businesses versus personal use or personal cultivation where there's no commercial activity involved. The DCC stands for the Department of Cannabis Control. This is the agency that licenses and has primary regulatory authority over cannabis businesses here in California. MALCRSA is the Medicinal and Adult Use Cannabis Regulation and Safety Act. That is the governing law here in California for commercial cannabis. CDTFA, if you hear that, that's the Department of Tax and Fee Administration. This agency regulates tax-related matters. They issue seller permits, and they will collect taxes, both the special cannabis taxes at state level and sales and use taxes, state taxes there. CEQA stands for the California Environmental Quality Act. This is a key state environmental law that cannabis licensees and applicants are required to comply with and to demonstrate that they've complied with it. And we will get into this later in more detail when we talk about provisional licensing. So those are certainly not all of the key terms, but those are just a few that came up in this presentation a few times. Right. Why don't we move on to first major topic, which is tax reform.
Cool. So, let's jump into it. Taxes are probably the thing we should talk about first, because probably the biggest challenge that legal cannabis businesses face in California is the immense tax burden. And, what we'll do on this slide is just highlight what that tax burden looks like. The tax burden for legal cannabis businesses in California basically exceeds any other state. Legal cannabis is often taxed 5 times before it reaches the end consumer in California. And again, just to tick through all of those levels of taxation and to kind of explain how this differs from other states, there's generally at least 5 taxes that legal cannabis are subject to. So there's the cultivation tax, and we'll talk through in a second recent changes to that tax. That's a flat tax that's been applied to cannabis since adult use sales began, and that's been indexed to the price of inflation. And so most recently, that cultivation tax was $160 a pound. And because it was a flat tax, as the price of cannabis dropped pretty significantly over the past 18 months, it became almost impossible to, sort of cultivate cannabis legally and profitably. So again, that's the first tax, which is a state cultivation tax. California has also had a 15% state excise tax that you pay at the point of sale. There's the local state sales tax that's applied to all goods in California. And then number 4 is a local excise tax that municipalities have the ability to impose on cannabis sales, which is generally between 8 to 10%. And then finally, jurisdictions can subject legal cannabis to local cultivation, manufacturing, and distribution taxes. So in short, those are all the taxes that legal cannabis is subject to, which is much bigger than any other state. And, a couple of things that, we'll just kind of point out on how California differs from other adult use states. Other adult use states like Arizona or New Jersey, they cap the local excise tax, the amount that a local municipality can charge as a tax on cannabis sales at 2 or 3%. But in California, that rate is often 8 to 10%. So that's one difference. And the other is, that cultivation tax, which is unique kind of among states. So just wanted to highlight that burden, how it differs from other states.
Sure, and something to think about as we're moving forward and the prospect of federal legalization looms near and near, it's worth thinking about. There will likely be a federal tax on cannabis as well. And so that is potentially another layer at some point that is going to be added on top of this. So it's a heavily taxed industry, as I'm sure you guys all know.
And I think, the combination of California having an entrenched and historic illicit market and these high rates of taxation have really contributed to the persistence of the illicit market.
Yeah, and something else that's worth mentioning while we're here, California NORML's done a lot of work around patients' rights. And there is, this is medicine for many folks. And yet all of these taxes are going to apply almost always. There is some limited exemption for folks who have one of the official state medical cannabis cards. But largely you have medical patients who are still paying a large percentage of their bill essentially in taxes. And so that's something that I'm hoping is going to change in the future.
Totally. And, we'll cover some of this on this slide. And so, probably everyone on this webinar already knew that California was a really high tax state. And I'm sure almost everyone on this webinar heard the outcries from the legal cannabis industry at the beginning of the year. Even some people suggesting that they wouldn't pay their taxes unless the tax burden was minimized. So I'm sure this is nothing new to folks. And so the question is, what did we accomplish this year? And I think the fair way to look at it is that we took a step forward, but much more needs to be done to lessen the burden on legal cannabis businesses in California. So, just to tick through some of the main things here, the big step forward is that the cultivation tax was eliminated as of July 1st. Now, again, this is a big step forward because when that cultivation tax was $160 a pound and the wholesale price of cannabis had fallen to $300 a pound, it made it impossible to run a legal business. So that was a good thing. But I think if we're being honest with ourselves, we'll recognize that, the excise tax, which many people wanted to see reduced, has been kept at 15%, which means that legal cannabis still won't be cost competitive. And, so it was a step forward, but still much more remains to be done. And maybe just a couple other things to highlight about this tax package is there was some relief granted to equity operators. So equity licensees in California are eligible for a $10,000 tax credit, and they actually only have to pay in practice a 12% excise tax rather than a 15%. So the burden on them was limited to some extent, but I think most equity operators would tell you that's still not enough for them to compete with the illicit market.
Absolutely. Yeah. And there was also in that same package some credits for retailers to offer certain employment benefits to their workers, which I thought was really great. I will just note that even though the excise tax has temporarily been capped at 15%, it can, after that increase to up to 19%. So I'm anticipating that we might see further adjustments in the excise tax, but this was certainly helpful, especially for the cultivation tax. And that's already in effect, these changes. And I believe that you've been sent some materials, and if not, you'll get it right after. There's some bulletins from CDTFA explaining these recent changes to the cannabis taxes.
Totally. And so, this was a big step forward, but as is noted here, California remains one of the highest tax states in the country. And so I think the question is what will happen going forward? And so I'll just touch on a few points, some of which, Lauren was alluding to earlier. So, medical patients in California are still subject to the 15% excise tax. So one of the interesting things we'll see is whether that might change going forward. Other adult use states like Arizona or New Jersey, they exempt medical patients from that excise tax. And I think there's a very strong moral argument that medicine shouldn't be taxed. And so I think it'll be interesting to see whether the industry can coalesce behind that kind of a proposal. Just the second thing to point out is that, many of us were hoping that we might get the excise tax reduced, but have come to the conclusion that many members of the state legislature are quite beholden to the recipients of that tax revenue. And so one question is whether the legislature provides the best avenue for reform. And many of you may know that folks in the industry are talking about a potential 2024 ballot initiative to reduce the excise tax from 15%, say to 5 to 7%. And obviously running statewide ballot initiatives in California is very expensive, but it'll be interesting to see whether that gains legs. And, I guess the final thing that we wanted to point out is that we are seeing some incremental reductions in local excise taxes, whereas the norm used to be 8 to 10%, at the local level. We're seeing cities shift to 4 to 6%, which is in part a consequence of more cities coming online and wanting to be more competitive.
Here is a screenshot that I took the other day of the CDTFA's tax guide for cannabis businesses page. They have this brand new thing right at the top that is explaining these recent changes to the cannabis taxes and how operators can deal with these changes. So we don't need to read through all of this, but you can see there's a link to where you can find this. It's right on that main page of that cannabis tax guide on the CDTFA website. And there's also some notices that they've issued in relation to this to help operators figure out how to deal with this logistically. When we're talking about the changes to the excise tax, previously and up until January 1st of 2023, the customer pays the excise tax when they go to a retailer, but the retailer then has to get that excise tax money to a distributor who then actually pays it, remits it to the state. That is going to change when come January 1st. And so the retailer will both collect and remit the excise tax money to the state. And so there's some guidance that is, to help retailers deal with this change. The retailers are now going to have to go get one of those cannabis tax permits that previously distributors have had to get. So there will be some more responsibilities on retailers come January 1st. But the way that the excise tax calculation will be simplified. This whole markup rate thing is going away effective January 1st. That's mentioned at the bottom. So I think that's good enough for that slide. While we're talking about tax issues, it would be silly not to talk about kind of one of the biggest elephants in the room, and that has to do with income taxes, in particular federal tax code section 280E. So because of this section of the Internal Revenue Code, there is cannabis businesses are not able to take their ordinary and necessary business expense deductions on their federal income taxes the way that other businesses are. They are allowed to deduct their cost of goods sold, but not the other business expenses. And so this as a result, cannabis businesses end up having a much higher tax burden typically than other businesses. And this can certainly be challenging. And it is important to work with a tax professional who's familiar with Section 280 and knows how to legally help you mitigate the burden on your business. I did add a note that when it comes to California, income taxes, they a few years ago have actually changed their rule after cannabis was legalized in the state of California. They agreed that it was not fair to treat, cannabis businesses way anymore. So for your state income taxes, licensed cannabis business can deduct their ordinary necessary business expenses in addition to their COGS. It is just at this point on the federal income taxes. And I've included 2 links below, one to the IRS that now has a website all about cannabis businesses and how you can pay your taxes and how they're helping cannabis business owners do this, and a link to the California Franchise Tax Board site about the cannabis industry and their tax requirements. So check those out when you get a moment.
Cool. Thanks, Lauren. And, that concludes our first topic. And so again, just to summarize, California has always been a really high tax state for legal cannabis. We made some progress with the elimination of the cultivation tax, but it's not enough. And if the legal market's going to gain an upper hand over the illicit market, we're going to have to do more. And I think it's an open question about how we do more. We may get some relief at the local level. The legislature may not have an appetite for reducing excise taxes. And so I think all of us in the industry are going to have to think over the next couple of years about how we make progress. So that's the first challenge of the California cannabis market. The second is the lack of retail access in the state. And like taxation, this is probably something that's pretty familiar to you. Just a few things we want to point out on this first slide. So as many of you may know, California likely needs 4,000 or more dispensaries to serve its legal market. On a per capita basis, if you compare California to other Western states like Washington or Oregon or Colorado, it should have 4,000 dispensaries. Now, as of today, there are 1,068 active type 10 or dispensary licenses in the state. And so just like taxes, it's really easy to understand why the illicit market is so prominent in California. It's because there's a lack of retail access, and there are vast swaths of the state where it's impossible to purchase cannabis legally. And so not only is legal cannabis much more expensive than cannabis that's purchased on the illicit market, it is just not convenient to purchase legal cannabis. So just the one thing we need to state is that we have a very long way to go in order to be able to serve California residents with convenience and allow the legal market to gain an upper hand. So that's a fact. At the same time, we think it's important to, look at the progress that we've made. And so as you can see here on the slide, at the beginning of the year, there were 836 active dispensary licenses in California. And now there's about 240 more. So we still have a really long way to go, right, to get to 4,000. But in the past 8-9 months, we've seen more progress than really what we've seen in the first 4 years of adult use sales. As many of you may know, so many of the legal dispensaries that are open today are grandfathered in medical dispensaries, the 200 in LA, a bunch in San Francisco. And so the pace of new license issuance over the past 4 years has been slow. So we have a really long way to go, but it is important to note that we have made progress this year. And then the other thing that we just wanted to sort of highlight is the number of new retail licenses that have been issued per month this year. And so you'll see it varies between 20 and 30. And one thing that really caught our attention is that the DCC issued an unprecedented more than 100 licenses in June. And as Lauren's going to walk through in a second, that may have something to do with the provisional license deadline. So just to wrap up this slide, we have a very long way to go to serve the legal market. And yet, over the past 8-9 months, we have started to see retail growth in California, which is encouraging. Cool. And so, on this slide, what we wanted to highlight, oftentimes what's cited is, how many dispensaries you have in California, as I was just describing. But the other thing that's important to note is where these stores are opening up. And so one of the things we're starting to see in California, as we've already seen in other states that have a local control framework, is that some cities get quite saturated. There's a high pace of license issuance in those cities. And so retailers are fighting for, pieces of a shrinking or a finite market, yet other, places remain deserts. And in order for the legal market to grow, you need stores to open up in deserts. So, just to put it candidly, another store opening up in San Francisco or in LA probably will only marginally grow that legal market, but a store opening up in deserts will grow the legal market. So here, what we want to highlight are cities that are in deserts that will have stores come online in 2023. And we just wanted to point out how consequential we think this will be for the growth of the legal market. So, I mean, just to pick a couple of examples here, Fresno, which is the 5th biggest city in California, has 500,000 people, has long had a totally illicit market with no access to legal cannabis. But over the next year, 21 stores there are going to open. And that city by itself could contribute $150 million in legal sales. Another example is Redwood City, which is in one of the wealthiest parts of California between San Francisco and San Jose, where there's no retail access. So, you know, the point is, although we have a long way to go for retail growth, we can point to cities that we know are going to open next year and that we know are going to contribute to the growth of the legal market.
Indeed, and if I can just make a note about one other here, I'm based in Sonoma County, and so Napa caught my eye. And it's interesting to watch. The city of Napa is very close to the city of Sonoma. They're in different counties, but they're close to each other. And the city of Sonoma has been talking about having 1 or 2 dispensaries for a while. They settled on it just being 1. They've awarded that to Spark. And the city of Napa, in the meantime, said, well, since our neighbor's only going to do 1, we're going to take advantage of this and we'll do 5, which for Napa, which was pretty conservative, that's a lot. You know, that was surprising that they went that route for me. And so we're seeing other jurisdictions take advantage of where others might choose not to allow something to regulate it that sometimes is compensated by a neighboring jurisdiction who realizes that this could provide benefit for their community and more jobs. So that one caught my eye just because I know of the dynamic between those 2 cities right next to each other.
Totally.
And I did add this bullet point about the local jurisdiction retail access grant program. So this is a program that wherein the state is essentially providing some funding to local jurisdictions to help them go through the process of adopting retail ordinances. So this is something that the governor mentioned recently, and it had been issued in the past. And so, you know, I was excited to hear about this. I haven't heard a ton about it in terms of press, but this could be one way to help jurisdictions who are wary or unsure about how to move forward with this to get some of that assistance from the state.
Totally.
Yeah, someone made a note, a lot of those cities are traditionally very conservative. Exactly. We're seeing cities and counties that that kind of waited it out for a few years because they were a little more conservative. They're now starting to come around once they see that the sky has not fallen in places that went first.
Totally. And, you know, on this slide, what we wanted to do is to highlight the number of cities that have had, you know, local retail ballot measures that have been circulating. So these are cities that either will have a ballot measure on the ballot in November, or where the threat of a ballot measure has led a city council to pass their own ordinance. And, you know, we wanted to highlight this for a couple of reasons because we thought it illustrates 2 basic truths about California cannabis. So the first truth that we thought it illustrates is just the big gap between where elected officials sit on legal cannabis access and where citizens sit on legal cannabis access. And these ballot measures are evidence of the fact that elected officials who often make these decisions are out of step with their own residents who by and large want legal cannabis access. And so these ballot measures have gained traction in part because the average citizen supports legal cannabis access. And, you know, again, we wanted to list these because this is a pattern that keeps repeating itself in cannabis in California every 2 years. Every 2 years, you see a couple dozen cities pass retail ballot measures, often against the will of the city council. And some of those cities end up being some of the most successful jurisdictions in California. So, you know, Vista, for example, in 2018 in San Diego County had a ballot measure pass over the objections of the city council. It's now one of the most successful jurisdictions in California. And so, you know, we think the same pattern will repeat itself where many of these ballot measures will pass or will force cities to pass ordinances, and that will increase retail cannabis access in California. So that's the first truth that we thought it illustrates how, you know, local control often involves, you know, elected officials sort of being at odds with the will of their residents. And the second thing we thought this illustrates is the big gap between when cities pass ordinances and when these stores actually come online. And I'll hand it over to Lauren to talk through that.
Yeah, so it's not as though the moment a city or county passes an ordinance that allows for cannabis dispensaries to exist in zones X, Y, and Z, that all of a sudden they're going to open up the following week. There's a very long process from when a local jurisdiction decides to actually regulate this and when folks in that community actually get access. And that is because there's local permitting involved. The state licensure process, you need to have a local permit and a state license, and you've got to show that you've got your local permit first when you go to apply for your state license. And local permitting, it's usually a use permit that's involved of some sort, and that can take many months, sometimes a year or more. There's typically a notice involved to the neighbors, a public hearing. There can be neighborhood meetings you have to do. You'll need to go through design review, get your building permits. It's a lengthy process. So that itself can just take time navigating that whole process. You might have issues with neighbors that don't want your business there. That's a challenge that a lot of businesses and applicants have to face. Another thing that comes up a lot is that these might be limited licenses in a jurisdiction. So they might only be offering 5 dispensary licenses in a town, for example. And so you can imagine that's going to be a very competitive application process. The city might get 100 applications for 5 available permits, for example. That's not out of the ordinary, especially when we're talking about dispensaries, which can be the most competitive. There's basically usually 2 ways that these application processes work when they're competitive like that. It's either a lottery, which has its own problems. You're not necessarily going to end up with the most qualified person if you're just picking them out of the hat or the applicant. But on the flip side, if you do a merit-based application process, then there's the question of, well, was the person or company who's doing the reviewing really being non-biased? And we've seen a number of lawsuits being filed over these local application processes for both of those reasons, lotteries or merit-based process. And that can slow everything down, whether you're the one bringing the suit or whether you're just one of the other applicants or the other folks that have been in the process that now everything's been slowed down or even paused. So that can take time. That's at the local level. And then even at the state level, the DCC can also take quite some time to process license applications. This varies a bit based on the type of license. The cultivation applications, for example, can take a bit longer than a transport-only distribution license. But that really is something else that you need to account for. It's not going to be a next day type approval. That could also you want to budget for a few months for that as well. So because of all that, like I mentioned in the beginning, there's going to be a delay between when places actually decide to finally take this on and when the businesses can actually be up and running. And so that's more time to wait before the jobs are created, before any revenue can be provided to the local community, and before folks there can get access. But better late than never in my mind, but it's not going to happen overnight.
And, I'll just say, I think the delays that Lauren was walking through, I think that's one of the most just like consequential characteristics of California cannabis. So, just to underscore some of the points that she was making, oftentimes we talk about the jurisdictions that haven't opted into retail, but really the biggest problem in California cannabis is that so many cities have passed ordinances, but 2-3 years later, none of those stores are online. And so it really exhibits the challenges of the dual licensing system in California. And so many of these cities are understaffed that they just don't have the ability to process this paperwork in a timely fashion. And, just a couple other points that I'll make. Lauren was talking about how the DCC can be slow to process these applications. I'll confess that like one of my biggest frustrations, what I would love is if we had visibility into the timeline that the DCC takes to process an average application and how many are in queue. I feel like that should be public information and would be useful to us. All that we have are these anecdotes about the people that we work with and how long it takes. So that would be great information sharing. And then, one other point I just wanted to underscore is that, these timelines end up having an equity impact. Only the most well-capitalized actors can afford to pay rent on an empty storefront for 3 years. So one of the consequences of this regulatory thicket is it makes it impossible for ordinary people to start businesses.
That's absolutely right. And, and it's unusual for folks to essentially just have to sit on a property, and there's really no guarantee they're even going to get the license at the end of the day. So it is a gamble, and in many cases, a very expensive gamble, even if you have all of your ducks in a row. So yes. We're going to move on to our next subtopic, which is provisional licensing and CEQA. And so it's going to get a little bit technical. I'll try not to get too deep in the weeds. There's some links here where you can go get some more information, and there's some handouts too that I was either already sent to you or will be sent to you right after this. So, we mentioned earlier that CEQA is the California Environmental Quality Act. That's going to come up in a moment. But what is provisional licensing? And you might have heard temporary license, provisional license, annual license. What's the difference? So just real quick, temporary licenses are not around anymore. Those were in the very beginning of the commercial cannabis licensing process a few years ago, when the DCC's predecessor agencies were still getting their regs adopted and figuring out what the actual application was going to look like. These temporary license applications were very short. They were just about a page long, asked for some very basic information. And they were approving them pretty easily left and right, because they were they being the predecessor agencies, were trying to get folks in the licensed market as soon as possible and out of the collective and cooperative kind of gray market area that it had been. So that has been phased out. That was phased out a few years ago. Annual licenses are the regular year-long license that comes with all the rights, privileges, responsibilities of a regular full annual license. So that's just a regular license is an annual license. It's good for 1 year, hence the annual. Provisional license is sort of this intermediary thing that the agencies came up with to allow folks who have not met all of the criteria to qualify for an annual license to still get what's basically equal to an annual license, as long as they show that they're working on those things. And it can't just be anything. There's pretty specific things that have to be the missing pieces in order for this to work. And there's a handout called Fact Sheet Requirements for Provisional Licenses. I've got the link to it there, but basically the things that could be missing, and one could potentially still be eligible for a provisional licensing provisional license. We'll talk about when there's deadlines later, but the items basically are having CEQA compliance not be fully done yet, having your compliance with your local ordinance not be fully done yet, not having the labor peace agreement documentation in place yet, and not having the Cal OSHA training piece fully done yet. So those are the things that one could potentially get a provisional license for. Now there's qualifiers on that handout and in the timeline on the next page that shows at what point provisional licenses can, stop being issued and stop being renewed for different types of licensees, and in certain case equity licensees. So this is it's a bit complex, but not really when you kind of look at it. I show you where we are here. We're between there was a big date on June 30th, as we talked about a few slides ago. All those retail licenses were issued in the month of June, because June 30th, 2022 was the last day for the DCC to issue certain types of provisional licenses. So they were kind of on their own deadline. They had to get it done by then, or they couldn't issue those types of provisional licenses anymore. There's others that could still be issued, but not the bulk of them, basically. And so we're now the next deadline, where now certain provisional license renewals from this point forward, there's going to be new conditions added. So when you're going to renew these provisional licenses now, an applicant is asked to provide documentation that shows that they're essentially working on or have completed those, whatever aspect they were missing, up to the standards that the DCC is looking for. And this varies if we're talking about something like the documentation for cultivators that shows that they are in compliance with the Department of Fish and Wildlife rules. They're supposed to provide a lake or stream bed alteration agreement, or some kind of documentation that shows that that's not needed. And if they don't have that, they're able to, for a short period of time, provide some documents that show that they're working on that. Same thing comes with CEQA. If they're able to provide some certain specified documentation to show that that's in progress, those are the types of things that they'll be able to keep renewing for. And again, this is all in that handout that was linked on the other page. So I do encourage you to take a look at that and to take a look at this timeline in more detail later, just so you can see for your clients when these different deadlines might apply for different clients. You might need to get some applications submitted to make sure they have their renewals in a certain time. If you're working with equity operators, they actually have a different timeline for a lot of these things. Larger cultivators are on a slightly different timeline as well. So if we could just go back one slide, I want to make sure I didn't miss anything on the previous slide. Yeah, so let me just go a couple more things on this one. So we touched on the first and second bullet points here, and appeal hearing rights. So one of the biggest difference between provisional and annual licenses are that provisional licenses do not have any sort of appeal rights. So if a provisional license is denied or it's revoked, that licensee or former licensee cannot appeal that and have a hearing. Whereas when you have an annual license, you have the right to appeal that decision. So that is a pretty significant difference, especially given that we're now going on a few years of these provisional licenses, when originally it was just supposed to be about a 1-year period. It keeps getting extended. So these businesses have been operating under these provisional licenses for many years now. They've been building their businesses. They've been kind of operating in reliance on all of this that the state is doing. And in some cases, it's not even their fault that they haven't been converted to an annual yet. The DCC just might not have gotten around to it. And now they've started to kind of reach out to folks and gather that information. So I know that, folks at my firm commented during the last round of comments, whenever this was up for comment, that they should get appeal rights, but that was not ultimately adopted in the final rules when it comes to provisional licenses. And then we touched on the varying deadlines. So you can go forward, why don't you go to the next one? There's a link to that fact sheet I mentioned. Just go back, just for 1 second. I also included some links here regarding CEQA specifically. And so there's a page on the DCC website about what does that mean for cannabis businesses? How can they show that they have complied with the California Environmental Quality Act? What kind of documentation is needed? It breaks down the difference, who is the lead agency and the responsible agency, and what exactly that means and who needs to prepare what. There's also a link to just general information about CEQA as well as the CEQA guidelines. So you can dig into that later. We could have a whole presentation just on that. So we don't need to get too deep in the weeds, pun intended. Next slide.
So the next is the illicit market. Before we go on to that, I just want to say, I think what Lauren was walking through really speaks to the heart of the matter, both the promise and the deep concerns one would have about the California market. So we were talking about how, hey, there's not a ton of retail coverage in the state, but stores are going to open up in all these deserts. All of these cities have ballot measures. Citizens support legal cannabis. So that's the promise of the California market. But I think what Lauren was walking through on the previous two topics was, despite the fact that citizens support legal cannabis, it takes a really long time for these stores to come online. And this new annual license deadline may make it even more difficult. So we may live in a world where the bureaucracy of California limits legal access points in California. And we'll have to see how that plays out. Cool. So two other main topics that we want to talk through on the webinar. So the fourth one is the illicit market. And here this connects back to the issues that we were discussing at the outset of the presentation. So, in short, at the beginning, we described how California is a really high tax state when it comes to legal cannabis. We also discussed how there's limited retail distribution points in California. And although we've seen some progress on those fronts, we still experience really significant challenges there. And so, the illicit market in California remains very large, in part or primarily because of those two factors, which is high taxation and a lack of retail access. And, the illicit market in California is currently estimated at $10 billion. But in truth, we really have no idea how big it is because it's so hard to estimate because it operates in shadows and in very rural parts of California. But most folks believe that the legal market has grown rather than shrunk since legalization. And just to state the obvious, that was the exact opposite of the intention of Prop 64. If you go back and read the preamble of Prop 64, The desire was to create a safe and regulated market. So we haven't made progress there for those two reasons. And just a couple other things that we want to point out on this slide. There's different components to the illicit market. So there's a big illicit retail cannabis market in California, primarily because in many parts of the state, you just can't buy cannabis legally. But there's also a really big illicit cultivation market, which isn't entirely California's fault. So long as prohibition exists in other states in the country, it's going to make economic sense to cultivate cannabis illegally and to ship it to all of these other markets. And so until the United States solves the federal state conflict when it comes to cannabis, California will have an illicit market for the foreseeable future. And this is important because a lot of actors have used this as an opportunity. There's a lot of sophisticated criminal enterprises that are far different than your average person selling cannabis on the street, who are operating in California. And not only do they sell harmful products, there's all sorts of environmental damage and other things that are happening as a result. And so unfortunately, until things change, we'll be stuck with a large illicit market for a long time.
Yeah, maybe if we can actually go back, I do want to make a quick note on something. I know we're going to save most questions for the end, but since this just came up, I noticed that there was a question about, evidence of harm to health from traditional cultivation. I think the concern there is more that these products are not being tested. And so just like as a best practice, if we're going to be consuming things, it's good to have an idea what's in them to make sure they're safe. There are a lot of chemicals that maybe shouldn't be used in products that are. And so really the concern is not that traditional cultivation itself is harmful, it's that there could be byproducts or other things that are in that cannabis. And if it's not required to be tested, it likely won't be. And folks really don't have that information about what it is. If you're growing your own at home and you know what you put in it and it's just for yourself, I honestly think that's a concern. It's folks who don't know the source of their product and what's in it. One thing that is interesting, though, if we're talking about harmful to consumers, one thing that is intended to be a benefit is the requirement that packaging be child resistant, right? We don't necessarily want kids getting into these cannabis packages, but sometimes the packages are incredibly hard to open. And so there's a debate over whether or not, there's a little bit too much in that area, and it can be challenging for patients who might have certain handicaps to be able to open these packages. So I think that we're still trying to find out where the perfect amount of child resistance is on these packages, so they're not also legal adult resistant, because sometimes they can be.
I also just wanted to build on the point that Lauren was making about testing. Some of you may be aware that there is a phenomenon in California of people going lab shopping, basically labs having incentive to forge the results of tests. And, I think that's a really big problem for the legal market. If the legal market's going to say, hey, buy from us, what, you know all the facts about this product. If the legal market has the habit of, shading the truth on that really diminishes the moral credibility of the legal market vis-a-vis the illegal market. So that's an interesting issue, I think.
Mm-hmm. Yeah, so I mean, it's going to take some creativity to really solve this problem. It's not something that just tax reform can change. It's not something that just opening up more access to licensing can change. It really needs a combination of these efforts, as well as really some form of interstate commerce. There's a huge demand for these products, and that demand is outside the state, and that demand is not going anywhere. So finding out a way to be able to legally get these products to folks in other states who want them could really help. Some of this problem could help the market issues here as well. So there are some efforts to combat this illicit market. As we've mentioned a few already, we talked earlier about these local jurisdiction retail access grants. There is SB 1186. I think Ellen has maybe an update for you in a little bit about where that is. That's a measure that would open up more access to retail licensing. I believe it would require a jurisdiction to at least have access to delivery, retail. And also I have included a link to the DCC's disciplinary guidelines, so you can check out what the penalties are for various things, including unlicensed activity. That's just one of the things that you can get penalized for. And then enforcement actions, you might have seen just today that the DCC published on all their social media pages. They did a big bust, like over $1 billion worth of cannabis, illegal cannabis that they confiscated. And so they are certainly taking some actions to go shut down unlicensed operators and then tell folks about it. So it's happening, and I think that it did not really happen for a while. They but there's money for them to do enforcement, and I think their goal was to not start too heavy-handed, and I think that that's appreciated. I mean, I don't want folks to be locked up for a plant, I really don't, but I also want this to be a fair playing field for businesses that are working hard to do things the right way. And it's, it sucks when other people are just cutting corners, and so we need to find out, how do we do this enforcement in a way that we're, again, not not creating a criminal justice problem for folks that might not deserve it, but also not creating a real economic problem for people who are working hard to do things the right way.
And, two things. Lauren was talking about SB 1186, two things about that bill that are worth mentioning. So, that's the bill that was sponsored by Scott Wiener. And what is interesting about that bill is it pits, I think, two competing ideals against one another, which is local control, like does a city have the ability to ban cannabis businesses, versus the right of people to access cannabis. And, cannabis was deemed an essential medicine in California. And, Prop 64 has really prioritized local control over cannabis access. But what's interesting about SB 1186 is it was an attempt to return to the principles of Prop 215 in 96, which said that cannabis is medicine and people have a right to access medicine. So it's just kind of a fascinating competition between two public policy values, right? Does a person's right to access medicine supersede a city's right to ban a certain business? And I think, many of us, all of us hope that, the rights of medicine win out. So I think that's interesting. The other thing that we just want to flag about SB 1186 is, the bill was pared down. As Lauren mentioned, it was pared down to only feature delivery and medical delivery. And yet the fierce opposition from local municipalities to the bill really took me by surprise, and it was eye-opening. So for me, it was a lesson in how important local control is to these jurisdictions. And if you see the ferocious letters that some of them wrote in opposition to SB 1186, it reminds you of how much local control matters to a lot of municipalities in California, to the detriment of the cannabis industry.
Mm-hmm. And to the detriment of patients and just consumers in that community. All right, so the last of our main topics that we're going to talk about are some new DCC regulations. And so here, I'm talking particularly about the most recent proposed changes. There have been a whole bunch of new regulations over the past few years. It seems like every time we get a hold of them, they issue some new ones. And so, but these are some of the latest proposals. At this point in time, they have not yet been adopted. They were proposed, and we're waiting to see if they're going to be adopted or not. I'm anticipating these will get adopted, but we'll see. And so just some of the highlights from this latest round of proposed changes would be including light deprivation in the definition of outdoor cultivation. This is a big deal for growers. Previously, light dep was considered to be a form of mixed light cultivation. Why does that matter, you might wonder? Well, mixed light cultivators, the licenses are more expensive, number one. And they have to provide a lighting diagram, which outdoor cultivators don't. Certain jurisdictions might allow one type and not the other. So there are some significant differences. I think the cost of the license probably being the biggest one. And so that is good to know. Light deprivation simply means excluding natural light. So not adding any artificial light, but like pulling tarps over it to create artificial darkness, basically. So that the proposal is to move that to outdoor cultivation. They're also proposing to clarify some what you can do with shipping containers. They had first proposed to kind of restrict what folks could do with shipping containers. They said things like it had to be permanently affixed to the land, and then they are coming back to clarify what they mean by that. Basically, there are lots of operators that have incorporated shipping containers or storage containers into their operation. Maybe it's for storage, maybe in certain cases it's for processing or something like that. But it is something that is being used, and so the agency has addressed it, and they hopefully should, be allowed to be used in the premises, not just for temporary purposes. We'll see how that comes down. There's some proposed rules about scheduled closures, allowing you to basically have scheduled closures and have it not be deemed, like you're forfeiting your license or anything like that. Some clarifications about employee break areas and solid walls. They had proposed some stuff about whether or not the walls had to go all the way up to the ceiling and things like that. Basically, that could be a challenge for some operators depending on the type of space you're in. They might have walls, but they might not go all the way up if you're in a big warehouse type thing. So anyway, there's some clarification around that would hopefully improve things. Delta 8 was mentioned in this latest round of proposed changes that would be included in the definition of total THC. That's something that we've been seeing a lot of, the Delta 8, Delta 10s, all these kind of other alternatives, sort of cannabinoids. Proposed changes to the labor peace agreement rules. So previously, or I suppose right now still, once you have 20 or more employees, an applicant has to attest that they will essentially enter into a labor peace agreement with a labor organization. They're proposing to reduce that to 10. And so that is a pretty significant change, because that's like half as many employees. So a lot of licensees that do not currently have to provide that attestation and that documentation would have to if this gets adopted. There was also some more changes regarding trade samples. So last year there was some laws and some rules passed about trade samples, and now there's some more clarifications and more information about trade samples, which are again fairly new in the industry. They're also proposing some changes related to branded merchandise. There's change in the delivery case pack value, which Hirsch will talk about in a moment. Proposed updates to the disciplinary guidelines in accordance with these. A couple more that are not on that list, but that are worth mentioning. Recently, the DCC also proposed rules about standardized testing methods and SOPs for testing labs. It'd be great if we can get all the labs on a standardized testing methods. That'll help avoid this whole lab shopping problem. Also, the Type 5 large cultivation license is finally gonna be available January 1st, 2023. So they have released some proposed rules related to those Type 5 large cultivation licenses and how folks could switch from multiple medium to one large, basically. So you can see all the current and proposed rules on the DCC's website at that link below.
And there's a couple of the proposed changes that Lauren walked through that I think are interesting and that are worth highlighting. The first is the LPA threshold that she was mentioning. And as she noted, the threshold for when you need to sign a labor peace agreement will be reduced from 20 to 10 employees, which is a significant change. And this takes effect, in 2024. What is interesting about this is there's many equity operators who have expressed concern about this rule. And so it's an interesting example of different constituencies in California cannabis and how their interests may not be aligned going forward, because many of these equity operators are struggling to stay afloat and are concerned about this provision. So people may have different perspectives on this issue, but it's a good example of where people may see things from a different angle. So it will be interesting to see how that's implemented and received. And the second one that Lauren walked through that I think is interesting and worth highlighting is the delivery case pack value change. And so, as many of you on this webinar know, running a delivery, running any cannabis business in California is hard, but it's very hard to run a delivery cannabis business in California. The margins are very low. There's a certain metric about the number of deliveries per hour that you need to make in order to even break even, which can be challenging in certain areas. And so, delivery case pack value starting in October will increase from $5,000 to $10,000, meaning the amount of cannabis that you as a delivery driver can have in your car will be double from 5 to 10,000. And what we'll have to see is how this impacts the delivery business. You know, there's a school of thought that, hey, if I have twice as much cannabis in my car, right, I can cover a greater geographic area, make more deliveries per hour, have a greater breadth of products that better meets consumer needs. I don't have to go back to the depot, which you have to do if you don't get a delivery every 30 minutes. And so I think there's a universe of operators out there that have set up delivery hubs across the state, especially given the lack of retail access in the state, who think they'll be able to run a really effective delivery business. And time will tell. And you know, the reason we bring this up is it hits on a lot of the issues we've been discussing in this webinar. You know, there's a lack of storefronts in California. There are huge swaths of the state where delivery would be really convenient. The illicit market competes on convenience. And so this can be one tool in the arsenal to help legal cannabis slowly gain an upper hand over the illicit market.
Absolutely.
So those are 5 main topics. And there's additional topics that I think we'd love to talk through. I'll let Lauren maybe highlight some of them if you'd like.
Yeah, so and I know that Ellen had a few things that she wanted to see. So Ellen, if you want to jump in at some point and provide the group with some legislative updates, be our guest. Now would be the time to do that.
Sure. At any point I can do that. I know 1186 was mentioned. That's that I just checked is still waiting for a vote on the assembly floor. The assembly has adjourned until Monday, so that'll be the soonest that that'll happen. I'll put in the chat a link to the sort of summary of the bills that CalNormal has been tracking this year. It isn't all of them. There's usually 50 or 60 bills every year, a lot of them minor or cleanup bills, but there are some important human rights bills. Our bill, and we're right at the end of the legislative session where all bills have to pass through the legislature by the end of this month, the end of August. And then Governor Newsom has he has a year to sign, a month to sign them. And so just very quickly, again, I'll put that link in the chat. Our bill 2188 to protect employment rights of marijuana users who use it off the job has passed through the assembly and is waiting for a vote in the Senate. Will probably happen on Monday. We're targeting specific senators and assembly people, and I've been sending out alerts. So if you get one of them, please take action, write some letters. I'll also put a link in to sign up for our alerts on that. Our second sponsored bill, AB 1954, to end discrimination from pain patients and others by their doctors who often drug test them and then throw them off their medications, has passed through both houses and is on Governor Newsom's desk right now. That's AB 1954. As is another bill that would expedite expungement of past marijuana convictions. That's a bill by Mia Bonta, AB 1706. And those, I think, are the ones that I want to highlight here, and you can look more and sign up for our alerts if you want to know more. I'm liking some of the questions I'm seeing in the chat, and I'd like to get to some of these other topics. So if no one has questions on that, I'll turn it back over to Lauren.
Yeah, and if we can just go back one slide briefly, Hirsch. So we had 2188 and 1954 and 1706 on here. So thank you so much for those updates. Just real quick, if I can touch on some social equity. It's a very big topic that we could spend a whole seminar on, but California, so the idea of social equity is that the war on drugs really harmed certain communities, harmed a lot of people, in particular certain communities really got effed by the war on drugs, to put it, how bluntly I can. And so the idea with social equity programs is let's try to help the folks who are most harmed by the war on drugs actually participate and succeed in this industry now that it's legal. And so this might be different ways to prioritize certain businesses, provide some financial incentives like tax breaks or fee waivers or things like that. to try to essentially give a leg up to these folks who have, suffered from a lot of disadvantages and setbacks due to the war on drugs. So in California, there's a state law about social equity programs, and the way it's set up here is that the programs themselves are really run by the local jurisdictions, the social equity programs, and not every jurisdiction has a social equity program. So what the state has done, though, is at least, regardless of whether or not your local jurisdiction has a social equity program, you might still be able to qualify for a fee waiver from the state if you meet the state's definition of an equity business. And so I didn't include a link to it, but on the DCC's website, there's information about equity fee waivers. So you can check that out. And it's possible that your clients might qualify. There's different ways they can qualify based on their criminal record, based on where they live, based on family members, things of that nature. So check that out. And then we can go to the next slide. We talked about patients' right and expungement. So the only other thing, Appellations, this could also be its own entire seminar. But this is a pretty hot topic. The state of California is rolling out an Appellations program for cannabis. It'll be the first of its kind in the world. And so you can check out that website to learn more about what's happening. The regulations have been adopted, and they're currently in the process of approving the folks that are going to decide whether or not the application is approved. So there's folks who are going to be reviewing the applications, basically. So they're assembling those folks. And then hopefully in the next few months, groups of cultivators can start actually submitting petitions to create an appellation of origin, which is like a designation that shows that this cannabis is from a specific geographic region and was produced with certain standards, and it's all tied to the terroir. So cannabis does have to be grown outdoors in the ground in order to qualify for this program. And you can think of things like wine and cheese and how they do appellations. They're more like how the European system is done than how AVAs are done in the US. So that's a super abbreviated version, but that is good enough for now. You can check out that website. And then we can go to the next slide. Just congratulations and happy birthday and anniversary to California NORML, 50 years. Doing really great stuff. So you can go to that QR code and check out some cool stuff. And then next slide. If you're interested in joining California's legal committee, here's some information about that. If you want to join the Cal NORML Legal Network, here are some of the benefits that you get if you join. And you can get more information here. These slides will be sent to everyone, so you'll be getting this information afterwards. Don't worry about having to write it down right now. But that will bring us to our Q&A. So we can start doing that. Let's see, we have some questions in the chat box. So I think we're probably just gonna, Ellen, do you just want to read through the questions in the chat box? Or do this a different way?
Muted. Well, I don't know if you've had a chance to look at those. Yes, the recording will be made available to attendees. I haven't had a chance to review all of them. So Lauren, it's your call whether you want to start addressing those in the chat or ask people to, people can raise their hand and ask to unmute.
Yeah.
I did see some kind of specific questions in the chat. One from Ed about should we advocate for something for
Confidential testing so traditional growers can test their cannabis. I guess I'm curious what you would mean by that. So anyone can go and like submit a sample to be tested and they would get the results back. And I don't believe those results are published anywhere unless the recipient chooses to publish them. So what exactly, what's your question getting at? Eugene, if you want to unmute yourself or maybe just clarify in the chat box.
Okay, I'm going to try to ask Ed to unmute. Let me get to Ed. hold on, Ed, I'm coming and gonna ask you to unmute, and then when you unmute, I think you can ask that question.
Okay. Um, if we think there is a potential danger in traditional cannabis because it's not tested, should we advocate for allowing it to be tested without that test also being an admission of traditional cultivation?
So I see. So like you're saying, should someone who is in the traditional market be able to have their cannabis tested, have some sort of a test result that they can show their traditional market customers? Is that what you're kind of saying?
Precisely.
Okay. I I I think the issue with that is that the lab would get in trouble for doing business with an unlicensed operator, right? So that rule would have to be changed first. And I think the concern is, I mean, yes, that would certainly provide some peace of mind to the whoever's getting that cannabis, but it also doesn't really help to solve the problem of the traditional market taking up essentially market share from the regulated market. And so it's a difficult balance because all of us here, you know, we are pretty much social justice minded. We wanted free cannabis prisoners. We don't think folks should be imprisoned for this. And I don't think that this should usually even be in something that's dealt with on the criminal side. But you know, as I was saying, on the flip side, there are businesses who are trying to do things the right way and are going through the expense and the time of participating in the regulated market. It's not fair for them when the folks cut corners. So it's a good question. I don't know if I would go so far as advocating for that myself, but again, there's nothing stopping an individual, a home grower, from submitting some of their cannabis to a lab that allows that, and you know, and having those test results. I would just make a note that it is against the rules for a testing lab to, you know, basically knowingly work with an unlicensed commercial operator.
Yes, but is that good for public health? If it's really estimated that quite a bit of traditional cannabis is on the market, and if this is really a risk, and I think with some of these, the larger new growers, it is a risk. Should we not, in the name of social justice and public health, advocate for harm reduction?
It's an interesting idea. I will say I haven't thought about that before, and I don't want to be so quick to, you know, to shoot it down. And it's some interesting food for thought. I'll give it that, because I think that in doing so, you're kind of taking away one of the strong arguments for telling folks to buy on the regulated market, which is that this is the tested product. And so if there's no incentive, if you're now removing one of the biggest incentives for folks to even buy from a licensed retailer, that could have some pretty negative downstream effects on the legal marketplace.
Ethically speaking, I don't think that's a good argument. But there are probably other questions we'd like to ask. Thank you for the time.
I mean, ideally, I'd like to get to where, you know, it's easier for the people in the traditional market to get themselves licensed. I had hoped the micro business license or something would enable that. And then that wouldn't be an issue, you know, then it would all be tested. I'd love to see the bar lowered for licensing.
Exactly. That's really what I think needs to happen. There are too many requirements. It's too expensive. It's just too difficult for most people to get licensed, and it should be a lot easier. It should be available to a lot more people. And I think that's probably a better way to go up. But I appreciate the question. That's a very interesting comment for sure. Let's see, other questions in here.
So Carl has written in quite a few things and has his hand raised. So Carl, if you're going to ask a question, make sure it is a question. Questions go up at the end, and And I'm gonna ask you to unmute. And yeah, if you want to ask
Hello.
a question, please go ahead.
Well, I have quite a bit. I'm from Catalina Island, and I have the medical license, delivery only license on the island. We are limited by federal waters, so we're medical only because there's federal waters that surround us, but we are able to participate medically. And even here, our city acknowledges that medical shouldn't be taxed. But even with that, we have a 10% sales tax and an excise tax on the product. And then we have exorbitant transportation costs. But the city of Avalon is also recognized as like one of the biggest desert cities, like you guys were talking about. We got some carve out for transportation on waterways because they forgot about us so much and we wanted to participate. Now, we did have a provisional license. We were having provisional licenses all the way since 2019. And I got to say that the narrative with the news says that the illicit market is like 4 to 1 or something like that to the legal market. And I would have to strongly disagree with that. I'm in a 1 square mile town and I'd invite anybody to come over here because I was one license and we have 30 people selling weed in 1 square mile.
So Carl, what's your question? Is it about the taxation, how to lower the taxation maybe, or address that?
Well, it's really, I just want to identify and point out that the Avalon and Catalina Island is a very good example and a microcosm. We're self-sufficient. We have to we don't touch other cities. So it's like we are a very good example of what goes right and what goes wrong and what the market's really doing, because we can't just go to our neighboring city to get something. And
you have to transport it in a golf cart, right? On Avalon.
no, we still have to have it in a fully enclosed vehicle. We still have to have that. Our vessel has to be a fully enclosed. We have to meet all the same requirements as a delivery vehicle on our vessel. But for a while, we didn't even have the carve out for waterways. We had to reach out to them and ask them for that, and they allowed waterways transportation. But we're not able to participate in the adult use market because of that federal water and because they don't acknowledge adult use. But because we're in California, we are allowed to participate in the medical market, and as long as we're following the state laws, they have to fall in line with that.
Well, there are other jurisdictions that are only allowing medical, but yeah, it sounds like you do have a unique issue there.
I would have Coast Guard, and Border and Customs board our vessel every time we're transporting across the water. And if we had adult use product on there, I wouldn't be talking to you guys today. But medical as a whole it's different. Even it just has to have that M or that A in front of it on that manifest. It's really that crazy. But I also wanted to point out that local control does matter, but I wouldn't even be here if it wasn't for the state before Prop 64. Local jurisdictions had to rewrite their cannabis laws to include adult use, or else their old regulations was null and void. And at that time, I found the opportunity in a very conservative, isolated town to prove the need by following all the state laws, and they wanted to prohibit it real bad. And I found we actually had a very big senior market that said that child resistant packaging was more of adult use, adult resistant packaging.
So this brings up another issue of the many wrinkles to the law that enter in because of federal law still being against us. Like, this is why one reason we have to fight for employment rights and pain patients' rights, and hospitals. There's another bill to allow it to be used in hospitals just among terminally ill, because there's federal funding for all those sorts of things. Even in our employment rights bill, there's a carve out for any requirements for federal drug testing, like anyone with a commercial driver's license. And so, part of NORML's work is to try to, change federal law. And we're closer than ever And that's something when people, sign up for our action alerts and sign up with National Normal too. And also there's local normal chapters that are working on local issues. I mean, if you've got 3 levels of government at play, and we really need to be active on all 3 of them, because each of them is going to impact us. And Jem writes in, she's correct. Don't forget about the inclusion of tribes, which is federal law impacts. So the answer is to get involved and let's change federal law. Looks like Charles Lozo has a question, so I'm going to ask him to unmute. He's got his hand up. Charles, do you have a question?
I do, Ellen. Thank you. First of all, congratulations to Normal for 50 years. Thank you, Lauren and her, for a wonderful presentation. The question is very simple. Can Normal track bills such as AB 1885 and its predecessor, AB 2215, that passed in 2018? The reason I mention those is I'm a co-founder and board member of the Veterinary Cannabis Society. And I imagine that it's a 501c3 that we started here in California with veterinary cannabinoid experts. We've been working against and with the Veterinary Medical Board and trying to push the availability of medical cannabinoids for canines and felines. And we have some of the top veterinary cannabinoids in the country involved in the organization. So the question is, can especially Cal Normal track the progress of the legislation relative to pets, including AB 1885, which Newsom is prepared to sign as far as I know?
Yes, actually, we are tracking AB 1885, and it should be on that page that I just sent out. And I was just commenting that even Republicans voted in favor of that bill, Republicans that voted against our employment rights bill. So it has, let's see, let me double check. There's actually, I'll put a link in. There's a place where you can sign a petition on that bill, petcannabis.org. Is that your organization, or is that an organization you're affiliated with?
Neither. The organization I work with is called the Veterinary Cannabis Society, of 501c3.
So it looks like the status of 1885 right now is that it still has to pass in the Senate. But it sailed through appropriations. I'm expecting it to pass in the Senate. I know someone who's working on that bill, and it's a popular bill. This is not the first time Assemblyman Cowra has tried this bill, and he has worked with various veterinary organizations on it. So I'm anticipating it's going to pass this year. So I'll put in the chat this link to where people can write a letter in favor of it. I see your very beautiful white doggie there in the picture. So is your doggie a cannabis user?
No, she's only 21 months old at this point. So
she doesn't need it yet.
no.
Yeah.
But I really appreciate.
Found out, some people were buying it for their pets, the anxiety version with a lot of CBD to help with anxiety around fireworks and things. And then there's higher THC versions to help with pain and arthritis. And so this bill would help make it easier for veterinarians to talk to pet owners and recommend it. And I haven't really seen any opposition to it. So.
Well, we've been tracking it very carefully at the Veterinary Cannabis Society. That it should pass. Newsom should sign it. It's very important because it protects the veterinary licenses. If they're discussing medical cannabis and recommending it, can't be revoked under business and professions code. The other thing I'll throw out to the group is that there's a very disjointed reality in the cannabis market under the DCC regs, because you cannot market a product for pets in the current environment, even though the regulations are clear that the legislature has manifested an intent that pets have access to this type of medicine. So there is an administrative resistance in the, not necessarily DCC, I believe it's in the Department of Consumer Affairs, that takes the position that manufacturers of cannabis products cannot be making things for pets because the two administrative regimens have not been harmonized. And while that doesn't rise to the level of all the human important things that are happening, a lot of us have pets, and a lot of pets need access to these important medical cannabinoids. So thank you, Ellen, Lauren, Hirsch, for a wonderful presentation. And I hope that NORML will continue to track the important legislation for medical cannabinoids for canines, felines.
Okay, great. Thanks for the work you're doing on that, and stay in touch about, future concerns around that. Because yeah, I'm not sure the legal status of, I mean, I see pet products in dispensaries, but maybe they're not on solid legal ground. I don't know. I haven't looked into that lately, but so great. Thanks for that. So we're actually at 5:30. If there are no other questions, let me see. I don't see anyone else's hand
I did
up.
see a question in the chat about the impacts of unionization on small businesses. I'm happy to talk to that.
Sure.
It's an interesting topic. I think this could be worthy of its own webinar. I'll just share some quick thoughts on this topic. I think first thing to just note is that there is a strong unionization trend in cannabis happening across the country. Like if you just follow developments across the country over the last 3 months, cannabis workers are organizing into unions at rapid rates, which I think is interesting. I think that kind of reflects in part the fact that a lot of the people who work in the industry are quite frankly dissatisfied. I think there's the perception amongst many people that a lot of money is being made, and a lot of people in cannabis, in their roles are not that satisfied. Maybe they perceive the industry isn't professional enough yet. So I think it's interesting to think about what is causing those trends. I also think from the perspective of organized labor, it's very smart to focus on the cannabis industry, just given it's a good way to build ranks. We're all familiar with the way in which unions have declined in this country over the past 4 decades. And so it's smart to focus on this sector. I'll just, obviously this is a topic where people have different perspectives. Without picking sides, I'll just sort of flag 2 things. One, it'll just be interesting, particularly in California, to see these 2 constituencies, right, which is the equity community and organized labor being at odds with one another potentially, right? And this is just an observation I've made from the comments I've seen. And I think a lot of these equity businesses, like cannabis businesses, find it very hard to stay afloat, and they're concerned about what this lower threshold might mean for their ability to be profitable. Now, on the other hand, someone might say, hey, this is merely a labor peace agreement, right? This isn't that your workforce is unionizing. This is merely you saying that you will not interfere with their ability to organize. And so, maybe these concerns are kind of misguided. And so, we'll see how that debate unfolds. One other thing that I'll just share is it will be notable to see whether the Supreme Court weighs in on this question, particularly this Supreme Court. The Supreme Court has held in analog cases that, making an LPA requirement a condition of licensure may be unconstitutional. Now, regardless of whether you agree with the Supreme Court or not, many of us don't, but that may be an issue that they take up. And that could disrupt a lot of these licensing schemes in blue states like California and New Jersey that have LPAs as a condition of licensure. So.
Interesting. Yeah. All right. So yeah, I'm seeing the discussion. There was some discussion around around unions in the chat. So, well, hey, I want to thank Lauren and Hirsch for putting together such an excellent program, donating your time in so many ways to the industry, and including this, and being on the CalNORML board. It's been, and thank you to all the participants. And if anyone has questions, you should have my email. I'll send it out to everyone again. I will send out that CLE form again if anyone needs it, but do please take a moment and fill that out. It helps us plan future programs. And it's something that CLE requires me to offer to all participants. And so it's good to see some new attorneys here. It's good to see some old friends, and still got work to do. We aren't legal enough yet, but we're sure working on it to make it legal, fair, and equitable for everyone as much as possible. And we appreciate everyone's input and participation in that.
Yes, thank you, everyone. Thank you, Ellen, for all that you do for the
Thanks to Ellen.
organization. All right, everyone, enjoy the rest of your Thursdays.
Okay.
Bye.
Thank you so much.